All right, 2-minute warning. 2-minute warning. All right, I want to welcome everyone back to our Civil Rights Conference commemorating the 70th anniversary of the Brown versus Board decision. If you've not been tuning in, I'll reintroduce myself. I am Kathleen Pate, Education Specialist here at the Clinton Presidential Library, and we're excited to bring to you this evening a special program featuring descendants of individuals involved with two key Supreme Court cases, Plessy v. Ferguson and the Harriet and Dred Scott case. My colleague, my partner in this endeavor, this conference, my local partner with the National Park Service is Brian Schwiger, and he will be our moderator this evening, and I'm going to invite him now to introduce our guest, our panelist. Thank you.
Thank you, Kathleen, and thank you all for attending tonight. It's a beautiful night here in Little Rock, and I'm glad we could be here to talk about something very important. We have, this week, been talking about Brown v. Board of Education, and its 70th year of commemoration, 70 years ago since the decision was handed down on May 17th, 1954. And I want to thank again the Clinton Presidential Library and Museum, our partners in Abilene, the Dwight D. Eisenhower Presidential Library and Museum, our partners in Topeka, another National Park Service site, Brown v. Board National Historical Park, our partners in St. Louis in this endeavor, Jefferson National Parks Association, our friends at StoryCorps, Humanities Kansas, the Eisenhower Memorial Commission, the Eisenhower Foundation, and the U.S. Commission on Civil Rights. Let's give them a hand. And then I want to also recognize this room of educators. This week, this group of intrepid educators have spent a week engaged in a professional development course that has brought many different viewpoints and many different perspectives, examining Brown v. Board, but also looking at other stories like we will tonight, like we did last night, stories that are critically important to be able to tell the full story of not just the civil rights movement, but the story of America. And so if our educators here and our educators virtually, if you want to raise your hands as well, let's recognize them. So if you've been to where I work, Little Rock Central High School National Historic Site, and you go to the building where we operate, which is right across the street from Little Rock Central High School, you'll see on either sides of the building some pretty important words. Let me read you the full citation of what's on our building. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. If you know those words, you know those come from the 14th Amendment to the United States Constitution, ratified in 1868. You cannot tell the story of the 14th Amendment without telling the story of Dread and Harriet Scott. And you cannot tell the story of Brown v. Board of Education without telling the story of Plessy v. Feguson. And so I'm grateful tonight that we have colleagues and friends here on the stage who are going to tell us the stories of their family, of their ancestors. And so tonight, I want to start off with Miss Lynn Jackson on the end and ask each of our panelists to introduce yourself and tell us about the organization you represent first. Ms. Jackson?
Thank you, Brian, and good evening, all of you. Thank you for being here. We are the Dred Scott Heritage Foundation, and Dred Scott is my great-great-grandfather. So in 2007, we officially incorporated the Dred Scott Heritage Foundation for commemoration, education, and reconciliation. And so for the last 18 years, I've been having programs like this and helping people like you understand so much more than you would ever know, as I've even learned so much as I've done the work. Thank you.
Mr. Keith?
My name is Keith Plessy. I am a fourth-generation descendant of Homer Plessy, to put it plainly. I'm first cousin 3 generations removed from him because my great-grandfather was his first cousin, and he had no children. So that explains it on the genealogy end and on the simple end of relationship to Homer Plessy. But I have combined my efforts with the lady that's sitting next to me here, Phoebe Ferguson, who is the other half of Plessy versus Ferguson from our history. But in our time, we have flipped the script on Plessy versus Ferguson, and our organization is Plessy and Ferguson initiative, and the word is "and" in the middle, not versus. Born in New Orleans, and we formed this organization, and also Phoebe's born in New Orleans as well, but we formed this organization in 2009. We met in 2004, and it took us about 5 years to come to grips with creating this organization. But we've been in existence for 15 years now and placed markers around the city of New Orleans to commemorate resistance and achievement of Black Americans. I'll pass it on to Phoebe.
Good evening. Thank you for having us tonight. My name is Phoebe Ferguson. I am the great-great-granddaughter of Judge John Howard Ferguson, who was the district civil court judge in New Orleans who first heard the case when Homer Plessy was arrested. And I am the executive director of the Plessy and Ferguson Initiative.
So let's investigate the stories that you just mentioned. For our educators and for those watching, again, you can't tell the story of America or the story of the civil rights movement without talking about these individuals. So, Lynn, if you would, answer for us, who were Dred and Harriet Scott?
Dred and Harriet Scott were two enslaved people whose lives were flipped when they decided to make a courageous move to claim the freedom that they believed and knew that they had. And their case absolutely changed the course of our nation. Dred was born in Southampton, Virginia, to the Blow family, Peter and Elizabeth Blow. They had 11 children. And those 11 children, most but not all, played a really significant role in the life of Dread and Harriet Scott as it proceeded even unto death. But the original thought was that Dred Scott would be their slave for life until they moved to St. Louis. And I'm skipping a lot, but we moved to St. Louis. And, but the difference between the Blow family and a lot of traditional enslaved and master relationships was that they did not treat him as though he was not a person. They had respect for him as an individual, and again, this will show as I tell the story along his life. In St. Louis, however, Mr. Blow became ill. His wife had died in 1830. When they moved to St. Louis, he died in 1831. And to solve debts, he had to sell property, things he owned. Unfortunately, one of those was Dred Scott. So Dred Scott was sold to a Dr. Emerson, who was an Army surgeon, and this Army surgeon took him to Fort Armstrong, which had been near Chicago, no longer exists, free territory, and he also took him to Fort Snelling, which is near Minneapolis, St. Paul, and that was the Wisconsin territories, also free territory. While Dred was with Dr. Emerson, he met and married Harriet Robinson Scott, who had come there by way of her owner, who was Major Lawrence Tolliver. Lawrence Tolliver was an Indian agent and also a justice of the peace. So when Dred and Harriet fell in love and wanted to get married, both their owners were in total favor of it, so much so to the point that her owner performed the ceremony because they actually had a real wedding. And also, his owner said she could come and live with him. And the quarters where they lived together in Fort Snelling still remains today and has been set up as part of the museum. You can see their living situation. But Dred and Harriet came back to St. Louis with the doctor, and in 1840, he passed away. He had been married recently to a woman whose father was very pro-slavery, Irene Emerson Sanford. So problem was there that Dred and Harriet said, you know, Dr. Emerson was pretty decent to us, but this lady, she's pretty cool, and cool meaning cold. And we don't know, maybe we need to figure this thing out, because actually we were in free territory, and the law said once free, always free. And that was the law. So one of the things I learned when I was doing my research is they weren't fighting to be free, which is what I think the general consensus has been, but they were fighting to get their freedom that they already had. Because having lived in free territory, both in Illinois and Wisconsin for several years, they were considered free by law. But when they came back to Missouri, Missouri says, oh, this is a slave state. We don't know anything about those other places. You're still a slave. And that was the pretense upon which they kept and held them in slavery. However, Dread and Harriet were a little sharp, and those Blow kids were standing around figuring this all out. And if we had a lot more time, I could tell you some really, really great stories. But ultimately what happened was they were able to sue Mrs. Emerson for their freedom, and did that on April 6th of 1846 at the old courthouse. It took a year for the case to come to trial, but when it did, in 1847, a jury of 12 white men gave them their freedom. Actually, they didn't. They didn't get their freedom. They should have gotten their freedom, but there was a problem. The lawyers weren't prepared correctly. And what they did was put a man on the trial that said, well, my wife says that Mrs. Emerson owns the slave, as they tried to prove her ownership. And that was hearsay. So with hearsay, the case was thrown out. It came back, but it took 2.5 years for various and sundry reasons. But on January the 12th of 1850, keep in mind 46 and now 50, they did get their freedom. And it was a jury of 12 white men. And they were freed by the law until Mrs. Emerson decided to appeal. And this set off a course of 11 years and 5 court proceedings. The Missouri Supreme Court, by way of Missouri, said that times are not as they once were when we used to adjudicate these cases. And no, we're seeing, too many slaves trying to get out of slavery, and no, we're not going to do that. And they just basically said no. And it was over until Roswell Field, and that's just a buzzword if you don't know the name. Roswell Field was the attorney who said, you know what? She's gone off to find another husband because her husband died, and her brother's taking care of her business now, and he lives in New York. So the diversity clause says that if you sue someone else who's in another state, you can take your case to the federal level. And that's exactly what they did. And this is where I feel like Dread and Harriet really showed their gut and grit, because they did not have to do that. After 6 years, and on March the 22nd of 1852, the Missouri Supreme Court said, no, you will never be free. The door was slammed shut, and it should have stayed shut. But Roswell Field gave them an opportunity. And it moved on until, at this point, March 6th of 1857, when the Missouri Supreme Court said, no, actually, you see, that once free, always free thing, we're not worried about that. What we're thinking is that you're not a citizen because you have African descent, and therefore you don't have any standing in court, and we're throwing this case out. I know. So after all of that time, 11 years, nothing, no consideration. But on top of that, what we now call activist judges, they also ruled that the Missouri Compromise was no longer the law. The Missouri Compromise said that when the states come into the Union, if a state is a free state, the next one will be a slave. The next one will be a free state, the next one will be a slave state. Keeping a balance, no longer all slaves. Every state comes in can have slavery. The other thing was the Northwest Ordinance, which said no slavery west of the Mississippi into the free territories. And they said that Congress had no right to ever put that in motion, which was back in 1820s. And so they threw that out. So now what you have is slavery from coast to coast. So we like to just put it in a nutshell and say the Dred Scott decision was a major catalyst for the Civil War. And it was. And the Civil War was fought from 61 to 65. Unfortunately, Dred Scott died 18 months after the decision, but he died a free man. And how did he die a free man? Not by the courts, but because of the help of the Blow family children. And one in particular, Taylor Blow, who bought $2,000 freedom bonds to free the family at peril and risk of himself if anything went wrong. And also, Harriet, by the way, I want to back up and say she filed her own case. She filed her case the same day that Dred did, so that they had 2 cases going through the system. In case something happened to one, they still had a chance of the other for their 2 daughters who they really wanted to be free. I don't want to go too much further because I'm conscious of the time, but Dred Scott lived another 18 months. He died on September 17th, which was Constitution Day. And the irony of that is that the 13th, 14th, and 15th Amendments, which are often called the Dred Scott Amendments, exist because of Dread and Harriet Scott's case. Those amendments, as you probably know, eliminated slavery, the 13th. The 14th, which Brian read earlier, gave citizenship to anyone born in America. And that was specifically for ex-slaves. And also is considered that which overturns the Dred Scott decision. And then the 15th Amendment gave the black man the right to vote. So the Dred Scott Amendments, AKA Reconstruction Amendments, those very pivotal, critical civil rights amendments that we always talk about, are born out of the fact that Dread and Harriet Scott said, we are free and we're gonna fight for our freedom. And they did, thank goodness.
And speaking, and you mentioned a place in St. Louis, and let's talk about, just real quick, and I want to do it with Keith and Phoebe as well, about these power of place places, like the old courthouse, or where the gravesite in St. Louis, to encourage, when you tell these stories, visit these places, put yourself in the place where the history of this nation swung. Can you talk more about the old courthouse and about the burial site in Missouri?
That's so exciting, yes. All right, the old courthouse faces the arch. It's just like 2 blocks from the arch, faces the river. And again, on April 6th of 1846, they went in and filed a petition for freedom, very courageous act. And then they went in on May the 26th to the old courthouse, the same building, and they got their freedom bonds and they got their freedom. That same courthouse for many years was considered St. Louis history, which it is, of course. And at one time, from someone long before I ever did this work, said to me, because family always did go there for occasions, and said, you know, this really isn't about Dred Scott. This is about St. Louis history. I just want you to be sure you know that. I go, I didn't ask you. But frankly, okay. But Dred Scott is a part of it. And that has flipped on its head to now where the old courthouse is closed for renovations, but the whole focus is becoming more of that history which has always been suppressed. And Dread and Harriet Scott will now have the whole northeast gallery for themselves, and it'll be a room at least the size of this one here, maybe a little bigger, but they will be told, their story will be told, and they will be known. And outside that courthouse on the same side is the first and only statue of Dred Scott, which our foundation, Dred Scott Heritage, commissioned and raised $250,000 for. So Dred and his wife Harriet are on that statue, and it's lovely. We had a local person win a blind evaluation to create it, Harry Weber. And so we're extremely proud of that. But at the same time, we just recently, in September of 2023, put a new headstone for Dred Scott in Calvary Cemetery. He originally was unmarked for 90-some years in 2 separate cemeteries. And in 1957, a granddaughter of Taylor Blow, that same family, who I work closely with and adore, she paid for a very modest headstone. It was about waist high, and it stayed there until last year when we were able to erect a 10 by 10 black granite 9-foot-high monument that has his image on it, has part of his eulogy from the New York Times, has scripture, but has his history, and it is phenomenal. I don't mind saying that because I did get to design it, but he deserved it. He is like the number 1, 2, or 3 top person asked for in a cemetery of over 300,000 people, and it's a beautiful cemetery. And so we're just excited that now when all those people who asked for him come, they can really learn who he is and see who he was. And it's just been wonderful. And there are more things in the offing, but that is some of the work that we have done. Thank you.
Who is Homer Plessy?
Homer Plessy was born in New Orleans on March the 17th, 1863, only a few months after Abraham Lincoln he issued the Emancipation Proclamation. And as Lynn was saying, the Civil War was pretty much fueled by Dred Scott's case. And Homer Plessy's connection to Dred Scott would show itself in his later age, because his case tied to Dred Scott v. Sanford would turn the century in the late 1900s, and it would lead to Brown eventually to overturn it. But in Homer Plessy's life, he grew up in what we call Treme area of New Orleans. There was a series of a movie that came out called Treme. Well, it was a series on HBO, and it told about that neighborhood and the history of it. But that's where he grew up. And he grew up, and people look at the name and say, well, Plessy versus Ferguson. And you think he was this guy with that last name, and the family had this tradition of, civil rights activism. But in Homer Plessy's life, one of the strangest things that happened to him was his father died at a very young age when he was about 6 years old. And the man who actually mentored him was his stepfather. His name was Victor Dupart. He didn't have to look far for, I would say, a positive figure of a man when his father died. And just to show you how connections are, my father was a master carpenter like Homer Plessy's father. My mother was a seamstress like Homer Plessy's mother. And his mother's name was Rosa, like Rosa Parks. But the connection with that, when his father died and Victor Dupart had to raise his family, he took in Homer Plessy's sister and Homer Plessy and his mother. And he was a civil rights activist. Victor Dupart was a former Civil War hero. In his family was the tradition of shoemaking. And if you look at the case of Homer Plessy, he was a shoemaker when he was arrested on that train. And the group that organized and put that case together was the Citizens Committee. This was a group of prominent citizens, 18 lawyers, businessmen, some white, some Asian, some black, multiracial group. And what happened was Reconstruction created this, I would say, utopia for freed slaves, black people who were free people of color. We actually had power in that period. We had more legislators and more congressmen, and in that period, we experienced progress. And what happened at the end of that period called Reconstruction was where Homer Plessy stood up as a young man, and he decided, when this law came out from the state of Louisiana called the Separate Car Law, he was dabbed to be the plaintiff in the second test case. The first test case was testing interstate travel. The man's name was Daniel Daydoun, if you ever heard of him. But his picture is in the African American Museum of History and Culture in Washington, D.C. Daniel was the son of Rodolphe Daydoun, who was one of the Citizens Committee members, one of the more powerful Citizens Committee members. And Daniel was a musician. And I know that people talk about New Orleans as the birthplace of jazz. And Daniel, being a musician in the Creole Onward Brass Band, proved that jazz was rebellious. And in Homer Plessy's case, he probably ushered in what we call the cradle of the civil rights movement of the 20th century. Because at the turn of the century, his case was combined with civil disobedience. He redressed his grievances in the courts, and they had peaceful protests, and also the press was used to advertise his case. Well, eventually, he went to U.S. Supreme Court with his case. It started out in New Orleans, and the railroad, if you didn't hear about that, the railroad was totally against segregation on the trains. When he protested in that incident, it was planned. The Citizens Committee had made a deal with the railroad to try to end these segregation laws that were spreading across the South. And their intention was to bring it to U.S. Supreme Court in the very beginning, even though it was a local case in New Orleans. So I want to pass on this mic to, well, Phoebe's mic so she can talk about this. Well, I'll tell you how it pretty much went this way when he was arrested. He was selected because of the color of his skin. He appeared to be white. He had 2 jobs. He had to get arrested and he had to get booked. So his job getting on the train was going to the train depot, purchasing the ticket, and the railroad knowing he was getting on there, he would test the segregation law by proving that he was white enough to buy the ticket, but black enough to be arrested for doing so. So when he stepped on that train, the conductor announced that he was a colored person. Nobody knew he was colored. He looked like a white guy. And when the conductor approached him, there was a detective who was hired to arrest him. And in that time, it was only 1 year before he protested on that train in 1892 on June the 7th. And in 1890, when they came about with this law, the Citizens Committee formed in 1891. Well, there was an incident on the docks between the Irish and the Italians. And a sheriff was murdered, and they were fighting for rights to sell things on the docks. And when the sheriff was killed, he was murdered rather, the Italians were blamed for his murder. And he was an Irish guy. He was a sheriff. David Hennessy was his name. And when he was murdered, the trial went on to try these 12 Italians for his murder. They were acquitted. And when they were marched out of the jail, I'll say a mob had formed. And they took these 11, one escaped, 11 Italians, and hung them from the ropes in Congo Square and shot them while they were hanging from the ropes. And the very next year, Homer Plessy decides, with the Citizens Committee, that they're going to challenge Louisiana's separate call law. So you can imagine the climate of hatred in that time when they protested against the segregation laws of Louisiana. And the case had to move forward. And when he was arrested, he was protected, in a sense, by the detective, because they rushed him off to jail to have him booked for that crime of violating the separate call law. So the case, moving on, went to the state Supreme Court of Louisiana, and then eventually to U.S. Supreme Court. And Phoebe will take it from here.
Thank you, Keith. Although he could have wrapped it up right there. But I will back up a little bit and say a little bit about who Judge Ferguson was. So Judge Ferguson was not a good old boy from the South, as many would believe, considering the ruling. He was born in Martha's Vineyard to a family of whalers, going back a couple of generations, and then he decided that he wanted to be a lawyer. And as a very young man, he went to Boston. And he did not attend university, but he studied under a senior attorney who was also an abolitionist. He completed his, I can't say degree, but law studies with him. And he actually opened up his office in Boston for a couple of years. And this started in the late 1850s. And so during the Civil War, he was studying and then practicing law. He did not join the Union Army. But after the war, in 1865, he decided to, like many others, to come to the South to start his career, really, a new life. And so he traveled to New Orleans. And he got here, he basically hung out his little shingle. And one of the things we know about his personal feelings about New Orleans was that he was really outraged by the sort of the red light district and the dancing and singing and celebrating that happened on Sundays in New Orleans. This was not okay with him. And he sort of made it his mission to shut down the red light district and curtail this, outrageous celebrating that happened on Sunday in New Orleans. So within a year, he marries the daughter of T.J. Earhart, who was a very outspoken abolitionist in New Orleans. And, but we don't have a lot of records of this, but not long after that, he gets involved in politics, and he kind of gets in bed with the Democrats, and they kind of push his career forward. But we don't know too much about really what happened between 1876 and 1892. I mean, there's not a lot of evidence. He's on the legislature for a couple of years. He goes back, he practices law, and then eventually, because of his ties to the Democratic Party, he gets appointed to the district court, civil district court in New Orleans in 1892, actually just after Homer Plessy was arrested. And, basically he's handling just, your basic cases, whatever came through the courtroom, right? And so after Homer Plessy was arrested and he was booked, they had to go to court. And so now Keith explained that the Citizens Committee had worked very hard with a lawyer named Abelard Tourget, a very, very, very important person to know about. He was an abolitionist and a writer and very key figure. And he had been watching the Citizens Committee planning this case because they had started their own newspaper and were writing about all of the injustices that were happening in New Orleans. And he volunteered to help them get this case to the Supreme Court. And that's really important. So, but there was also a local lawyer because Albion Tourget lived in North Carolina and then in New York. His name was James Walker. James Walker is a former Confederate soldier who's now defending Homer Plessy. And so they bring their case. They've figured out they're going to challenge the separate car law, which mandated that anyone who was not of the white race had to ride in a separate car, ostensibly an equal car, a car not any different than the first-class car. So Walker and Tourget prepare this case on the 13th Amendment and the 14th Amendment, essentially, although they brought before the judge a 15-point plea, but the real points that were key that would get them to the Supreme Court were the 13th and 14th Amendment. And so with the 13th Amendment, the reason that's important is because by separating the races and basically saying that the other race is a second-class citizen, that was a badge of servitude, which is part of what the 13th Amendment got rid of by freeing the slaves, but also you could never again take a race, the black race, and make them a second-class citizen, and this is why. And then the 14th Amendment, of course, is that once the 14th Amendment was passed, it was everyone was supposed to have equal rights. And so this kind of separation was, according to the amendment, illegal and had been outlawed. And so they felt they had a pretty strong case. So in November of 1892, the case does come before Judge Ferguson. They make their pleas. It's interesting how prepared they were, because you have to think about, they had to think about, okay, if this one doesn't work, what's the next one? And so they took on the color question, right? So when Keith said part of their strategy was they're going to hire a conductor, they're basically saying that the conductor had to decide arbitrarily, this one person, whether this person is black or this person is white. And of course, in New Orleans, there was so much blending that who should say who has the right to determine what race you are? And the separate car law said that if a person violates the law, then they're going to be subject to a $25 fine or imprisonment. If a conductor doesn't arrest someone riding in the first-class car that's black, they're subject to a $100 fine. And so they were serious. So anyway, they make their plea, and Judge Ferguson says he needs to go and think about this. And he comes back 2 weeks later in November, and he says, you all have made a really great, your arguments are very intelligent. You've really done great research. But the one thing that I don't see here is that nobody has, if the cars were unequal, no one has said so. So of all the points that they had prepared for, they forgot this one little thing, which was to prove that the other train cars were not equal to the first-class car. So Judge Ferguson said that basically the separate car law had standing as a legislative law, and that he had to uphold it, or would uphold it. However, he did not set a trial date. Not setting a trial date meant no conviction. No conviction meant no habeas corpus, and there was a delay. The delay allowed Plessy's lawyers to appeal the decision to the state Supreme Court. So they did that, and the state Supreme Court allowed for hearing the case, but of course they also upheld the separate car law as being just, as being, not injustice. What am I trying to say here?
Not unjust.
Unjust, thank you. And so they kind of, like smirking almost, saying that, yes, we agree with Judge Ferguson, and we are upholding this law as not being in any way a problem. As a matter of fact, they said, we don't even understand why you're bringing this case to court. I mean, what? The cars are equal. What's the problem here? You know, and and just hold on to that thought, because it has a thread, you know, and so that was good also for the Citizens Committee, because the goal was what? What was their goal? The Supreme Court. So they were able to now, on a writ of error, appeal the case to the Supreme Court. And the Supreme Court allowed them to take the case. And now there was a 4-year delay in getting the case before the Supreme Court. In that time, if they had any hope at all that those justices might rule in their favor, it it waned because some members of the court changed over that time. And the Citizens Committee got pretty depressed about it. I mean, it was taking forever, and the chances that it wasn't looking so good. Finally, they get to the Supreme Court. The Supreme Court, at that time, there wasn't a Supreme Court building, correct? It was held
In the basement of the Capitol building, and not really the U.S. Supreme Court that we know that Brown was decided in.
right. Short story is that they make their case. Albion Tourget is there. There's another lawyer who represents them at the Supreme Court. And the Supreme Court, again, narrowly interprets the case and denies Homer Plessy a victory. And there was and so the judge, the majority opinion written by Justice Brown said that, that he didn't feel that, just sort of went out of my head, that that Homer Plessy had any rights to the case, and the separate car law was legal because it was a states' rights law, for one thing. That was one way in which you can also see today this is replicating. Replicating is it a state law or is it a federal law? Who gets to decide? So they rejected the case, and Homer Plessy is convicted of a federal crime. And although that doesn't make sense because it was a interstate law, but
Well, it was a state law.
I don't mean a federal crime. I mean he was convicted and had to go back to New Orleans. Or he didn't go to Washington, but in New Orleans he had to pay his $25 fine in January of 1897. But what we hadn't thought about really for a long time as we go around and talk about the case is the fact that Homer Plessy then had to live the rest of his life as a convicted felon. And that was brought to our attention recently by a civil rights lawyer who thought that was very significant, especially since a couple of years ago was the 150th anniversary of the day he was had to go in and pay that fine and was convicted. And I'll let Keith say a little bit about the pardon, something we worked on, if that's okay.
I don't want to take up a whole lot of time saying this, but that pardon happened in 2022 on January 5th, one day before the anniversary of the insurrection, which was strategically planned by the governor of Louisiana. We got that pardon when Mary Howell, a lawyer that Phoebe explained, found in a book that it was illegal to charge Homer Plessy that $25 fine and make him change his not guilty plea to a guilty plea. And therefore, he was a convicted criminal as a result of that. But it was forced upon him. So it was room for him to get a pardon. And what we did, we brought it to the district attorney of New Orleans and our present district attorney, Jason Williams. And he has a civil rights division in his district attorney's office. So they did the research and they found the Avery Alexander Act, which was written for specifically the Freedom Riders, people who went through the sit-ins, who were arrested during the 60s, and they refused to take the pardon. So it sat on the books from 2006 when it was written, all the way to 2022 when we got the pardon from the State Board of Pardons. The governor refused to sign it in 14 days because he wanted to make a public event of it, and he wanted to make a public apology. And the beauty of what happened for us was that all those folks came together to do that for Homer Plessy, but there was something happening in St. Louis that had been happening for years. And they were trying to remove the state charges, just like our governor of Louisiana removed Homer Plessy's charges, which was a state charge. And the legislature in St. Louis in the same year, in March, tell me if I'm wrong, Lynn, the 26th?
You kind of close. Let me take it.
Yes. To relate it, just listen to this.
Yeah, this is awesome, and I wasn't even thinking about this. There's so many wonderful stories here, people, but what Keith's referring to is the fact that the Missouri legislature in 2021 unanimously voted to renounce the March 22nd, 1852 Dred Scott decision at the Missouri Supreme Court level, which said times are not as they once were. And we did start this process to ask them to reconsider this because it's not like they could overturn it, but they certainly could renounce it. And that started around 2014. And COVID came in there and it just got stretched out for various and sundry reasons. And I want to be fair and say it's not because nobody wanted to do it, but things just happened, but we kept persisting. So it was actually official in 2021. However, there was COVID. So a wonderful story ensues as to why, but we ended up having what we called a celebration of renunciation in 2022. And in 2022, it was the 170th anniversary of that Dred Scott decision in Missouri. So I had Keith and Phoebe and several other people come to St. Louis and participate in that. And we literally just gave thanks to God for the fact that He is working these things out in our day and time and that He is using us.
Both in the same year, which was so amazing that I can tell you that I'll share a moment with you. When the Plessy pardon was announced, and I participated, that we all did. Unfortunately, we didn't invite you, Lynn.
I noticed.
But the thing is, when it was happening, it was so emotional that we had to wear the mask for COVID. And I stood there when the governor signed all those papers, and I felt all that emotion. I didn't drop a tear. But I felt like the tears were right inside my chest. But when I went to the Dred Scott renunciation of his charges, my mask for COVID was soaking wet. I cried for every preacher that stepped up on that podium. And you know, it was a strange thing that I had to sit. There was a gentleman who had presented the legislature with that, the young man who was sitting next to me, and he had a funeral to attend. So when he left out the church, I'm sitting in the middle of the church, right in the front by the podium, and every speaker seemed like they were talking directly to me.
That's what happens in church.
So I couldn't hold back the tears. It was so emotional and so beautiful. And I tell you, it was a little footnote at the end. Now, I'm a bellman, and I've been a bellman for 44 years working for Marriott. And
It's really good, too.
I'm the most unlikely person in my family to be the one to tell this story. I have professors in Virginia in my family that never stepped up and talked about Homer Plessy's history. But when we were leaving out of Lynn's church, that's not your church. That was Dred Scott's
It was where
church.
Harriet Scott went to
Yeah.
church, however. Yes,
Yeah.
it was Harriet Scott's church. It's still going.
Well, we just happened to be loading up the car, and what's the lady's name? I'm trying to think of the lady that works with you. I'm trying to think her name, but I can't think of it. I will later.
Shannon?
No, Lois. Lois?
Oh, Lois.
Lois.
Okay, yeah.
We're loading the car up, and Lois says, Keith, what kind of work you do in New Orleans? I said, well, Lois, I'm a bellman. She said, did you know Dred Scott was a bellman? I said, wait a minute. Dred Scott was, I've been knowing Lynn for 10 years, and she ain't told me nothing about that.
Shame on me.
So, you know, it's a thing where I carried it through the 15 years we've been doing this work. And, you know, I always thought I was the oddball around, you know, professors, historians, archivists, and we're all having these conversations. I'm saying, I'm a bellman. So I felt like the oddball until I heard Dred Scott was a bellman. And then I knew something drew me to this that was beyond my control. So I dedicate my life to it.
So I want to, before I ask you, and I know our time is drawing to a close, but I want to thank you all for mentioning the intentionality. It's a hard word to say it at night. but how intentional Homer Plessy was and how intentional Dred Scott was. So many times we hear the story that Rosa Parks sat on the bus because she was tired, and how Homer Plessy intentionally did this and put himself at risk. And Dread and Harriet filed this case, not with somebody else's lead, but on their own. The intentionality of what they did never needs to be lost, and it needs to be taught that these individuals ran toward something and didn't run away from something. So talk about, we mentioned power of place. Talk about what you two have done in New Orleans to preserve that power of place.
Well, we have 2 books that I will suggest that you might want to read to learn more about the case of Plessy versus Ferguson. That book is We as Free Men, Plessy versus Ferguson, and it is written by Keith Weldon Medley, who's the author of that book, and the guy who actually introduced us. We didn't know anything about each other until that guy brought us to his book signing and introduced us. And we went alongside of him, but one of his dreams was, and we had Hurricane Katrina hit us the year after we met. We met in 2004. Hurricane Katrina ravaged New Orleans in 2005. So when Keith introduced us, his idea was that if any storm ever hit New Orleans again like Katrina, that we would never know that black people ever existed if we didn't put up markers to indicate the resistance and the achievement that black people made in New Orleans. So when I mentioned in the beginning about what we do, those markers are number of 5 in New Orleans that we put up so far over 15 years. Each one tells a story about some serious resistance and achievement that black folks faced throughout Jim Crow, through the Civil War, Reconstruction. And Keith's idea is what we live by. We still, till today, are putting up markers in the city of New Orleans. And there's another book by the name of Together, just one word.
The inspiring story of the case that divided America.
Separate but equal. Yeah.
That's right.
And that book is a story of our childhoods and how we faced segregation in our lifetime and how that history affected us as children and how we grew up together and eventually met and took that idea of being separate and unequal, because it's never been equal, and take it and turn it around and become friends and set out to tell the truth about history. So it's been our mission to do that.
This maybe we have to close with this because I know our time is almost up, but speaking of your mission and speaking of intentionality and speaking of the descendants from which you have come to us tonight here in Little Rock, talk about how, and we'll start with you, Lynn, talk about how your connections to these stories and these people and this life-changing history motivates you to do what you do in the pursuit of greater social justice and racial equality.
Okay, that got deeper and deeper. How much time do we have here? A minute and a half. Well, I can do that. Okay, so first of all, yes, part of what we want to be sure you go home with is the fact that we were blessed to be able to fulfill a dream I had of descendants of other famous people meeting together. And I started to pursue them, and I was a little not lucky, but then all of a sudden they just started dropping out of the sky. And I always wanted to meet the Tawney family. Chief Justice Roger B. Tawney read the Dred Scott decision, and that has happened. And not only are we very, very connected and travel around the country speaking, but Charlie Tawney, a great-great-great-nephew, gave a public apology to the Dred Scott family in front of the statue of his ancestor 3 weeks before it was taken down. And our work together has been phenomenal, as well as his daughter has written a play about descendants meeting and talking about the case. And it's absolutely stunning. It's called Dred Scott Presents Sons and Daughters of Reconciliation. Of course, Keith and Phoebe are part of it, as is Cheryl Brown. So we have the Scott, Plessy, Ferguson, Brown panel. We have many, many others. However, this work by itself, when I said commemoration, education, and reconciliation, I knew the first two like the back of my hand. I was not sure what was going to happen with the third one. But as Providence would have it, it has come together, and it's the most powerful of them all. And so for us to do what we do, share what we share, and all of our stories, I mean, none of us knew each other. It's like a magnet that just has drawn us together to do our work, and everybody was doing their own thing. And this by itself proves that it's a new day and new things can happen. And so my minute and a half is probably up, and I'll leave it at that. Thank you.
Just one comment, I know you probably want to say something, but there's a person missing from this panel, and her name is Cheryl Brown Henderson, because the three watershed cases in American history and civil rights and in Supreme Court is Dred Scott, Plessy v. Ferguson, Brown v. Board. And the descendants of those families, we are close friends. You know, Cheryl's not here, but that makes the complete trifecta.
Oh, and may I add real quick, too, that I am also very much involved with and work with the Blow family, who owned Dred Scott originally. And like I said, the younger, one of the most younger ones, who paid for his freedom bonds, also paid for his plot at Calvary Cemetery. And he moved him from an unmarked grave, which was going to be destroyed after 9 years of his death, and moved him to this big Catholic cemetery and bought 3 plots so he could be there. And he had to buy 3 because a black person could not be buried next to a white person. So we took that unkind intention and turned it into the 10 by 10 beautiful monument that he has today. And all things work together for good.
And all of this is called restorative justice. So acknowledging past harms and finding a way to address them, acknowledge them, address them, and take an action that will change the way we look at history and the way that we now have to think about the conflicts going on today within our communities and our states and our nation and the world, is that we must be a part of the efforts to acknowledge history and bring people together to have these very difficult discussions, and then take an action to restore the harms. And so this is what the Truth and Reconciliation committees in South Africa have done, is to have those hearings and have people tell their stories of great harm and injustice, and then find a way to honor that trauma and bring people together. So that's something that when we first started working together and we were pursuing the marker initiative, we hadn't really learned the terminology of transitional justice, transformational justice, and restorative justice. But that is now very much a part of the conversation of how giving us language and methodologies and of how we can think about these things. And so as the country is hugely divided right now, a very positive thing is that at the same time, there are many organizations, I think Kellogg is one of the largest that really began to write down what Truth and Reconciliation was about and how to think about it, and giving people a framework to have these conversations. But that's happening all over the country too. So there's the negatives out there, but there are people working together to try and say, we have to educate the public, and we also have to hear the raw stories so that people who are making these horrendous, accusations and can understand what the real effect it has on people.
Wow, this has been an incredible night, and selfishly, let me just ask you to do this for all of our educators. When you teach these two cases this next school year, don't give power to that case. Give power to the people behind it and the stories that you've heard tonight of Dred Scott and Harriet Scott and of the struggle of Homer Plessy, and take that with you tonight as you leave. Thank you for being here. Thank you so much. We hit the dot right on the nail right on the head. So have a fantastic night. Thank you for everybody who tuned in Kansas and beyond, and we say good night.